All right, I think we're going to go ahead and get started. Just another quick reminder, please, if you could please leave your microphone and your videos off during the presentation, that would be great. It helps decrease the distractions. Also, if you have questions, please type them in the chat box and I will relay them to our presenter after the presentation. And if you need a certificate of participation, please contact Marilyn and she will get that out to you. So for today's topic, we have Milena, who is a compliance investigator with the Department of Labor and Human Rights, and she is going to be talking about service animals. So I'll turn it over to you, Milena.
Thank you so much. My name is Milena Stojkovic. I am compliance investigator with the North Dakota Department of Labor and Human Rights. I've been with the department for almost 20 years. My duties involve handling wage and hour issues, investigating wage claims, complaint inquiries, and also investigating complaints alleging discrimination in different areas such as employment, housing, public service, public accommodation, credit transaction, etc. Also, part of my duties involved education and outreach, and that is the reason why I'm here today. I thank you all for participating. I hope you'll find some of the information interesting. And I recall once attending some conference that some smart person said, if you take it's worth attending any presentation, any conferences, meeting, if you take one thing away that you can use later in your business. So I hope you'll find some of the information helpful, and we'll certainly have time to address as many questions as we can at the end. So couple information about the Department of Labor and Human Rights. We are a state agency. We're also a cabinet agency. We have several divisions. We're a relatively small department, but we have, as I said, different areas of activities. We have wage and hour division, human rights division, and education and awareness. Human Rights Division enforces, and our whole department enforces several state laws. Human Rights Act, which is part of Century Code, Housing Discrimination Act, Whistleblower Statute, and Public Employee Relations Act. The department, as I said, enforces several laws, and one of them is Housing Discrimination Act, and we'll make references throughout this presentation to Fair Housing Act and Housing Discrimination Law. So when we talk about discrimination, we have to know what discrimination basically is. What is the most simple definition of discrimination in housing? Basically treating someone differently in the sale or rental of housing because of that person's membership in a protected category is actually discrimination. Singling person out or a group of people with similar characteristics out because of their membership in a protected category or protected categories. So basic or fair housing laws that the Department of Labor and U.S. housing providers should be aware of is Fair Housing Act of 1968, which is the federal law, and State Housing Discrimination Act of 1999. Department of Labor has a work sharing agreement with HUD, U.S. Department of Housing and Urban Development, to accept complaints and dual file them with HUD, and those complaints allege violation of federal law. And because of that work sharing agreement, we have authority to enforce those laws as well. So when we talk about discrimination and protected categories or protected classes, um, there are some differences between protected classes under the federal law, Fair Housing Act, and and under the state law. Under the federal law, Fair Housing Act, protected categories are race, color, religion, sex or gender, national origin, familial status, meaning having children under the age of 18 or being in process of obtaining custody of minor children, and disability. Under the state law, there are a few more protected categories, and they are race, color, religion, national origin, sex or gender, familial status, disability, receipt of public assistance, such as, let's say, Section 8 voucher, etc., marital status, single, married, divorced, etc., age pertaining to individuals who are 40 and older, and also certain victims of domestic violence. Um, so those are the protected categories under the state law. There are additional in comparison to the federal law. So these laws prohibit discrimination. Um, However, there are certain exemptions from these laws. For example, an owner who has 4 or fewer rental units or dwellings, and the owner lives in one of those units, that owner is exempt from state and federal housing discrimination laws. There are also some religious exemptions, private club exemptions, and housing for elderly, which is specifically designated and certified as housing for elderly. So certain activities can be exempt. However, a housing provider, an owner, landlord, or its agents are never exempt from state and federal housing discrimination laws for making statements, publishing, or advertising that's about the sale or rental, which would indicate preference, limitations, or discrimination because of the person's protected classes or class. For example, verbal statements, newspaper, social media, advertisement, publications, etc. Um, examples of those statements or advertisement, except for older person, private clubs, as I mentioned, and religious organizations. And the standard used to assess whether those statements are discriminatory, that standard is a reasonable person standard, meaning whether an ordinary listener, a reasonable person, could view those statements as discriminatory statements expressing certain preferences. It's always good practice when landlord or owner advertise property for rental to describe the property rather than to describe tenants. For example, one can say the spacious 2-bedroom or 3-bedroom apartment with amenities close to shopping mall or major roads, etc. So describe the property rather than say um, perfect rental for single individuals or elderly individuals, or no males, or something which would refer to potential tenant. So that is worth keeping in mind. So today we're going to talk a little bit more about service animals and assistance animals. So there are two types of assistance animals. One is service animals and other animals that do work, perform certain tasks, or provide assistance, or provide therapeutic emotional support for individuals with disabilities. These animals are often called support animals, companion animals, assistance animals, emotional support animals, therapy animals. People use different terms to refer to these type of animals. So the service animal under the Americans with Disabilities Act, which is also federal law, and you most likely are familiar with that law, is defined as a dog that is individually trained to do work or perform tasks for benefit of an individual with a disability, including physical, sensory, psychiatric, intellectual, or any other mental or psychiatric disabilities. Um, Other species of animals, whether they are wild or domestic, trained or untrained, are not service animals for the purpose of this definition under the ADA. The work or task performed by the service animal must be directly related to the individual's disability. So that's also worth keeping in mind. So when we talk about performing work or task, what does that mean? That means that a dog is trained to take a specific action when needed to assist the person with disability. And if a person with disability identifies at least one action that that particular service dog or service animal is trained to take, which is helpful for disability other than emotional support, the dog should be considered as a service animal and permitted in housing, including public and common use areas. And housing providers should not make further inquiries. If no specific work or task is identified, then that dog should not be considered a service animal. However, that dog might be another type of animal for which a reasonable accommodation may be required. That dog might provide emotional support, comfort, for well-being or companionship that is not specifically work or task for the purpose of analysis under the ADA. The, as I mentioned, the emotional support animal must alleviate or help some symptoms of disability. So the presence of that animal has to be directly related to the need of a person with a disability. Um, These emotional support animals have been known to assist disabled individuals with severe depression, anxiety disorders, PTSD, post-traumatic stress disorder, and many other emotional or psychiatric or psychological disabilities or impairment. An emotional support animal is a type of animal that is recognized as a reasonable accommodation for a person with disability under the fair housing laws, both state and federal. The difference between service animals and assistance animals, as I mentioned, the service animals are categorized as animals trained to do specific tasks for the owner, and the most common is a guide dog, eye-seeing dog, for example. However, there could be others. I recall having um, a case where a person with disability has a dog who was trained or had ability to sense that the person with disability would have a seizure. So that dog would alert his owner, a person with disability, to sit down or be in comfortable position or away from sharp objects if person would get a seizure so he would not hurt himself. Um, an assistance animal can be a cat, dog, or any other type of companion animal. And that animal does not need to be trained to perform service. The emotional or physical benefit, just the presence of that animal, um, living with a person with disability in his or her home is what qualifies that animal as an assistance animal. Um, An animal that does not qualify as a service or assistance animal is actually pet for the purpose of fair housing laws and may be treated as pet for the purpose of lease and the housing providers rules and policies. Sometimes you have situation where landlord has no pet policy. Um, and in that situation, landlord has right to enforce that policy and not allow pets on his or her premises. Um, in that case, a landlord, if landlord has pet policy, in that case, landlord may be able or is allowed to charge fees or deposits or charge for damages, for example, if that pet causes. Um, However, those charges and fees, pet deposit cannot be charged um, to a person with disability who has service or companion animals. So if the animal is a dog, cat, small bird, rabbit, hamster, or other rodent, fish, turtle, or other small domesticated animal that is traditionally kept in a home for pleasure other than for commercial purposes, then a reasonable accommodation should be granted because the requester has provided information confirming that there is disability-related need for that animal. And for the purpose of this assessment, reptiles other than turtles, barnyard animals, monkeys, kangaroos, or any other type of domesticated animals are not considered common household animals under the fair housing laws. There are also individuals who would like to keep some unique animals. If the individual is requesting to keep a unique type of animal that is not commonly kept in household, as described, has a burden, substantial burden to demonstrate a disability-related therapeutic need for the specific animal or the specific type of animal. It's always encouraged that the person who is submitting requests for reasonable accommodation to submit documentation from a healthcare provider confirming that need for the animal, that it's necessary for that person to have that animal living with the person. So when we talk about service animals, companion animals, assistance animals, we always tie that to a person with disability and reasonable accommodations. So sometimes, as I said, person might need to have unique animals. For example, the animal is trained to do work or perform tasks that cannot be performed by a dog or cat. And information from a healthcare provider should confirm that, for example, allergies prevent a person from using the dog, or without the animal, the symptoms or effect of this person's disability will be significantly increased. And the individual seeks to keep the animal outdoors, for example, at the house with a fenced yard where the animal can be properly maintained. So these requests for individuals who want to be allowed to keep a unique animal should not be automatically dismissed. One should look into it. Um, for example, as far as unique animals, let's say an individually trained monkey can perform tasks for a person with paralysis caused by a spinal cord injury, and that monkey has been trained to retrieve a bottle of water from the refrigerator Unscrew the cap, insert the straw, and place the bottle in a holder so that individual can get a drink of water. The monkey is also trained to switch lights on and off and retrieve requested items from inside cabinets. The individual has a disability related need for this specific type of animal because the monkey can use its hands to perform manual tasks that a service dog cannot perform. One common question that household housing providers receive is for reasonable accommodation to providers no pet policies that so that individual with disabilities are permitted to use assistance animal in housing, including public and common areas. And under the fair housing laws, um, it would be unlawful for housing providers to refuse to make reasonable accommodation that a person with disability may need in order to have equal opportunity to enjoy and use the dwelling. Sometimes a landlords might think that if they treat all their tenants or applicants in the same manner, they would be safe. However, sometimes treating all tenants in the same manner might be discriminatory. Um, the law says to deny accommodation, the landlord must prove that such accommodation is not reasonable, not necessary, or causes an undue burden to the landlord. Causing an undue burden to the landlord must be based on objective, specific information, evidence, cannot be based on speculation, perceptions, etc. Um, Most requests for reasonable accommodation involve one animal. However, sometimes it can involve more than one animal. For example, one can have a person with disability um, who has a need for two animals or more animals, or sometimes you have situation where there are two individuals living in the same household and each of them have disability related need for a separate assistance animal. One might have a need for a dog, another might have need for a cat or bird. Um, Again, when we talk about service animals and companion animals, that's always tied to disability or disability related need. So what does disability mean? Disability means, or this is most simple definition of disability, means a mental or physical impairment that is limit that substantially limits at least one major life activity, or a person might have a record of this impairment, or a person might be regarded as having this impairment. So this definition has three prongs. The term physical or mental impairment includes, but it's not limited to, variety of diseases, conditions, or impairments, and they can be physical or psychological, orthopedic, visual, hearing, speech. You can see yourself from the screen, all variety of impairments. Keep in mind, also drug addiction is included. However, current users of illegal drugs are not covered under this definition. So that's worth remembering. The term substantial limits suggests limitation that is significant or to a large degree um, compared to general population. That is the assessment. The term major life activities mean those activities that are of central importance to daily life, such as seeing, hearing, walking, breathing, performing manual tasks, working, caring for oneself, learning, speaking, so variety. So again, a person with disability is entitled to receive a reasonable accommodation. And so the question is how that requests can be made. Under the fair housing laws, a resident or applicant for housing or participant in any housing program would make a reasonable accommodation request when he or she makes it clear to the housing provider that he is requesting an exception, change, or adjustment to a rule, policy, practice, or service because of his or her disability. Um, that resident or applicant should explain what type of accommodation he or she is requesting, and if the need for accommodation is not readily apparent or obvious or not known to the provider, then a person with disability should explain the relationship between the requested accommodation and disability. Basically explain why he or she needs that particular animal for his disability. What does that animal do for this person? It is not necessary under the law to make a written request or to use magic words such as reasonable accommodation or assistant animals or any other, as I said, magic words to request a reasonable accommodation under the fair housing laws. However, these individuals are always encouraged um, to be very specific in order to avoid possible miscommunication and misunderstanding. Um, Persons with disability may also want to keep a copy of their request for reasonable accommodation and supporting documentation just in case that there is later dispute about when and how and whether request was made. And likewise, housing providers may find very helpful to have a record of requests or at least a note in renter's file, um, and maintain a list of these requests and actions taken. One of the major questions that we receive is, can a landlord ask for documentation, and what documentation, as far as medical documentation or any documentation related to such request, a landlord is entitled to? Well, the short answer is maybe. It all depends. If a person's disability is obvious or otherwise known or just um, apparent to the provider, and the need for the requested accommodation is also known or obvious, then the provider might not request any additional information about the requester's disability or disability related need for the requested accommodation. However, if the requester's disability is known or obvious to the provider, but the need for the accommodation is not readily apparent, so the landlord does not know why this person who is in a wheelchair or who has impairment or disability, why that person needs a certain accommodation, including service animal or companion animals, then in that case, that landlord or that housing provider may request only that part of information, which is necessary for the landlord to evaluate whether should provide reasonable accommodation or not. Housing providers may not ordinarily inquire as to the nature and severity of individuals' disabilities. Housing providers are not entitled to receive diagnosis or specific information about treatment and how long person has been, having this condition. However, in response to a request for reasonable accommodation related to assisted animals or, companion animals, a housing provider may request reliable disability-related information from person's medical provider that is necessary to verify whether the person meets the definition of a person with disability, meaning having mental or physical impairment that substantially limits him or her in one or more major life activities, describe the needed accommodation, and shows the relationship between the persons with disability and the need for the requested accommodation. So basically, housing providers have to have information. Is this person a person with disability? Number one. Uh, does this person need accommodation, and what is that accommodation? And what is the relationship between the service animal or companion animal and the person's disability? How is that animal necessary to this person with disability? That's basically what um, reliable information should provide. Um, I'm sure lots of you receive, if you are housing providers, you might be getting more and more of documentations from the internet. Some websites sell certificates, registration, or documentation, letters, etc., um, verifying that the person is in need for assistance animals. To those who answer a questionnaire or certain questions or participate in a short interview and pay certain amount of money. Um, However, U.S. Department of Housing and Urban Development and our department's position is a housing provider may request reliable documentation when an individual requesting a reasonable accommodation has disability or disability related need that are not obvious or otherwise known. In HUD's experience, such documentation from internet, it's not by itself sufficient to reliably establish that an individual has a non-observable disability or non-known disability and disability-related need. However, keep in mind that many legitimate licensed healthcare professionals deliver service remotely, particularly these days, including over the internet. Um, One reliable form of documentation is a note from a person's healthcare professional that confirms person's disability or the need for the animal when that provider has a personal knowledge of the individual. So current treating physician or current treating therapist, which does not always necessarily have to be doctor, can be a social worker or anybody who has personal knowledge. For example, a rental applicant who uses a wheelchair advises a housing provider that he wishes to keep an assistance dog in his unit, even though the provider has a no pet policy. So in this particular case, an applicant's disability is obvious. The person is in a wheelchair. Um, he has a mobility impairment, but the need for the assistance animal is not obvious to the provider. It's not known. In that case, a housing provider may ask the applicant to provide information about his need. Why is this animal necessary for him and how that animal relates to his disability or her disability? So there are only two questions that a housing provider should consider with a request for assistance animal as a reasonable accommodation, assistance animal and service animal. Number one, does the person seeking to use and live with the animal have a disability? And does the person making the request have a disability related need? In other words, does that animal work, provide assistance, perform tasks or services, or benefits this person in any other way as a companion or provides emotional support that alleviates one or more identified symptoms or effects of a person's with disability? So those are the two main questions that a housing provider should ask and consider when assessing any requests for reasonable accommodation related um, to service or companion animals. And no answer to either of these questions mean that housing provider is not obligated to make a reasonable accommodation. This means that person either does not meet the definition of a disability or that assistance animal does not help with symptoms with disability. And in that case, a housing provider is not required to provide reasonable accommodation. If the answer is yes to both of these questions, then the fair housing laws require an exception to a no pet policy or pet rule, and a landlord would be required to provide reasonable accommodation. Um, with regards to pet deposit and pet rent, which is often issue with related to assistance animals, keep in mind that service animals and assistance animals are not pets, period. According to the joint statement issued by U.S. Department of U.S. Department of Housing and Urban Development and the Department of Justice, housing providers might not require persons with disabilities to pay extra fees or deposit as a condition of receiving a reasonable accommodation. And the Department of Labor and Human Rights uses these documents as guidance in cases regarding reasonable accommodations. Um, Often there is a question, what if another tenant also has disabilities such as allergies that won't allow for the service animals to be in the unit? I recall years ago, I had a case where a tenant made a request for reasonable accommodation to have a cat as her assistance animals. However, that tenant or that person with disability has a neighbor or next door tenant who had severe allergies related to cats. And so in that particular case, we might be talking about competing disabilities where the landlord might be required to provide reasonable accommodation to both of these tenants. Sometimes the solution might be to move one tenant away from another. In this particular case that I mentioned, if I recall correctly, a solution was found that there was an air purifier that was installed. Um, I don't recall whether it was in a unit occupied by tenant with a cat or another unit who had severe allergies, but that was solution. So keep in mind that a situation has to be looked at, assessed, and see whether there is way to provide accommodations to both. Again, housing provider, in addition to not being able to charge pet deposit or pet fees for assistance animals or companion animals, a housing provider might not charge a fee for processing requests for reasonable accommodations. And again, can't stress enough that pet rules do not apply to service animal and support animals. However, um, there's nothing in either state or federal law that would prohibit landlord to impose certain rules or conditions as far as upkeep of these animals or cleaning after the animals. For example, the law wouldn't prohibit a landlord to enforce rules related to having, let's say, dogs, companion animals leashed when outside of tenant's unit, or if a tenant has a bird, to have that bird in cage when exiting or entering the premises, picking after the animals, disposing waste, etc. That is not prohibited. Um, Housing providers also may not limit the breed or size of a dog, for example, used as a service animal or support animal just because of the size or breed. However, it can limit based on specific issues with the animal's conduct because it poses a direct threat or fundamental um, alteration. Often there are landlords or situation where a person may have a pit bull. That's very frequent issue. And in those cases, just based on perception or information related to sisters in-laws cousin had a pit bull who was involved in some biting accident, for example, uh, just because that knowledge, a landlord cannot automatically deny request for accommodation to a tenant who also has a pit bull unless that particular animal was involved in accident which poses safety issues or direct threat um, to other tenants or the landlord himself. A housing provider may not charge fees, deposit, or surcharge for an assistance animal. Again, it can charge those fees to related to pets, but not to assistance animals. Um, However, housing provider may charge a tenant for damage an assistance animal causes if it's housing provider's usual practice to charge for damage caused by tenants or deducted from their security deposit. A person with disability is responsible for feeding, maintaining, providing veterinary care, shots, and all that, or controlling his um, or her assistance animal. The individual may do that on his own or with assistance or family, friends, or volunteers or other providers. Before denying reasonable accommodations requests due to lack of information confirming an individual's disability or disability-related need for an animal, a housing provider is always encouraged to engage in a good faith dialogue with the requester, person who is requesting accommodation. And that dialogue is often called interactive process. If a reasonable accommodation request is denied because it would impose a fundamental alteration to the nature of the provider's operation or impose an undue financial or administrative burden, a housing provider should still engage in the interactive process to discuss whether an alternative accommodation may be effective in meeting the individual's disability-related need, whether there is something else that the housing provider can provide, which is not exactly what the requester asked for, but could have a same effect to the person with disability or same benefits. Often people ask, how do I know what to do or what not to do? You know, the main issue is get educated. Um, you can visit our Department of Labor and Human Rights website or HUD's website. You can call Department of Labor, visit with your attorney who is knowledgeable in these fair housing laws. Keep in mind that if you contact us, we cannot discuss your specific issue. For example, we cannot tell you you are doing right or don't do this or don't do something else. We cannot provide legal advice and talk about specific situation you might have because potentially we can get a complaint and we cannot give legal advice. However, we can always point you to right direction, provide some resource materials, or inform you of legal requirements. Um, what we always recommend is to document everything. That will make it much easier for you and for your tenants, um, program participants, and also for us, in case there is complaint filed. If you have documentation and that is reliable documentation, you can easily defend yourself or explain what action was taken. Uh, Keep in mind when it comes to service animals, companion animals, what is important to remember from this presentation is that it's always related to disability. Um, if disability is not obvious or the need for assistant animals or companion animals is not obvious, you, as a landlord or owner or housing provider, you can ask for reliable information to verify the request and provide requested accommodation unless those accommodation cause any undue hardship to your business. Um, Also, don't make rush decision, but also don't drag your feet. Don't delay responding to these requests because in certain situations, unreasonable delays can be viewed as a denial of these requests. And train your managers, those who are directly working with your tenants, applicants, dealing with public. Um, they have to have certain knowledge or very good knowledge with regards to these issues. Um, be familiar with the law. If you are not, very familiar, then there are individuals such as attorneys who have experience and who can provide legal advice, and be consistent in your policies and your practice. Here are numbers that you can contact us. This is our general number, toll-free number. You can email us or you can go to our website.
All right, we have quite a few questions.
Okay, sounds good.
Hopefully we can get through them all. This first one came from an individual. I'm not sure if he's on the presentation, but he had emailed it earlier just to make sure we got it asked. But he says, at Overlook Ridge, we have a policy against dogs. My question is, are we supposed to allow some who have a note from their physician for an emotional support animal into our building? She has lived here for several years, and the dog in question is not always here, only once or twice every so often, and not on a regular basis. We are not sure how to proceed.
Again, I can't talk about this specific situation because I would be then giving an opinion on a potential complaint, which we cannot do. But in general, I've noticed through working on these type of cases for so many years that sometimes landlords will say, well, the person moved in and lived here for a year or longer period of time and never needed anything. Now suddenly person needs to have a dog. Do I have to provide that reasonable accommodation? A person with disabilities can request reasonable accommodation at any time. It doesn't have to be at the beginning of their tenancy, but it also can be. Applicants can make a request for reasonable accommodation. Those who didn't even sign a lease yet, they can make that request. During their tenancy, at any point, people can make a request. So this particular landlord has a no pet policy, okay, does not allow dogs. But if this tenant is a tenant with disabilities and has reliable documentation from medical provider verifying that that person is a number one person with disability, number two, that person is in need of a reasonable accommodation, having specifically to have a dog um, on with living with her and being in all areas of the landlord's premises, which includes um, common areas, day rooms, TV rooms, computer rooms, laundry, etc. Not only in their unit, but they have to have access to any other areas where other tenants have access. And if that particular dog is beneficial to this particular tenant with disability or helps this tenant alleviate some of the symptoms of that disability, then in this case, that tenant may be required to provide exception to his or her no dog policy and allow that person to have that dog on the premises, regardless how often.
Okay. Next one, I think, has to do with the first part of the presentation. I know a landlord who lives in his apartment unit, but it has 9 units. That would not exempt him from discriminating, correct?
That is correct. That is correct. Only owners who have 4 units or less and live in one of them are exempt, but not exempt from discriminatory statements ever.
Okay. Is a dog in training considered a service animal?
It's you know, it might be, you know, if it's trained or in training to provide certain task or certain, provide certain help to a person with disability, it might be. The dog might be in training to learn how to do certain tasks, for example, to alert that somebody is at the door, but at the same time, that dog might not be completely trained, but at the same time, that dog might be providing companionship to a person with disability or providing some other emotional support to a person with disability. And in that respect, that dog can be assistance animals, viewed as assistance animals.
Okay. If it's a puppy, does it have to be housebroken before being allowed?
There is nothing in either state or federal law that addresses that specific issue. Again, a tenant is required to clean after the dog and, maintain um, apartment clean or in order. If there is any damage, if a landlord charges other tenants for damages or ruining the carpet or, eating baseboards, etc., then in that case, a landlord has right to charge for damages this particular tenant who is a person with disability and has puppy as a service animal or companion animal.
Okay. Does the person have to be receiving SSI or SSD in order to have a support animal, as long as that person has documentation from a doctor?
Um, there is no specific requirement under the law. Both state and federal housing discrimination law does not say if person is receiving Social Security disability benefits, that person is automatically a person with disability. There is no reference in either law like that. What the law, state and federal housing discrimination law says, people with disabilities are those who either have one or more major substantial limited impairment, that substantial impairment, either physical or mental, that substantially limits them in one or more major life function. Uh, Definitions under the Social Security Administration regulations and fair housing laws might be slightly different. Most often or very often, I've seen that people who are receiving Social Security disability benefits also meet the definition of disability under the fair housing laws.
Okay. If the unit is considered no pets, does landlord have to allow an assistant animal if the tenant wants a unit in that building?
Again, if the landlord has no pet policy and an applicant or a tenant is a person with disabilities that needs to have a reasonable accommodation, and that person has either need for a companion animal, assistance animal, or service animal, then by requesting from a landlord to allow him or her to have that animal, that person is actually requesting a reasonable accommodation, which is exception from that policy, to make exception from that policy and allow that tenant to have that reasonable accommodation or that animal, so that tenant can have equal access to the use and benefits of that rental as other tenants who do not have disability and who do not have need for reasonable accommodation involving service animals or companion animals. What that animal does to this person with disability is the same what the wheelchair does to a person who has mobility impairment. That's the easiest maybe way for people to kind of comprehend, what that animal is. It's like medication, it's like wheelchair to a person who has mobility impairment. So in order for a person to have equal enjoyment and be able to live in that unit, that person needs to have that animal. And so the landlords would be required to make exception from exemption from that no pet policy, unless providing such accommodation would cause undue hardship to a landlord, to business.
Can the provider who provides the documentation allowing the animal be held liable if something happens while the animal is on the property? For example, an emotional support dog attacks another resident.
Can you repeat the first part of the question,
Can the
please?
can the provider who provides the documentation allowing the animal be held liable if something happens while the animal is on the property?
I'm not sure I can answer that question. What the uh, health provider should provide is to verify that the person, his or her patient, is a person with disability, does have a need for certain animal, and that animal is beneficial to this person with disability in this and this in this respect. Okay, so that's all what what the health provider should verify or provide. I'm not sure that any health care provider could guarantee that animals would not get involved into any accident. There could be certain liabilities, and that's often defense on the landlord's parts. If a dog barks, or if a dog, shows some kind of aggressiveness, oftentimes landlords was denied reasonable accommodation, say, this is causing personal liability, or causing me to be liable for any potential lawsuits, or from other tenants if such incidents occurred. But I don't know how would healthcare providers be liable just for providing information. This is my patient. I've been treating this patient for the last so many years. This patient is a person with a disability. This dog or cat or bird or whatnot is beneficial in that, minimizes or reduces symptoms of disability. That's all.
Okay. If we allow two pets and they have four animals, but two of them are assistance animals, do we have to permit all four?
Well, again, fair housing laws don't regulate pets. So it's totally up to landlords whether they want to allow pets or they don't want to allow pets. So that's totally up to housing providers, landlords. So they can allow and impose certain rules, including pet deposit, pet fees, pet rent, whatnot. With regards to, I can only talk about fair housing laws addressing the issue of reasonable accommodations related to service animals and companion animals. If those out of these four animals, two are assistance animals or companion animals necessary for or for a person with disability, and it's verified disability, verified need, in that case, a landlord might be required to allow that those two animals who are assistance animals or service animals. But with regards to pets, it's up to landlord. They can or they might not allow them.
Okay, so this, we just have a couple left. This one's kind of a two-part, maybe a three-part question. If someone has lived here for 5 years paying pet rent and they get a doctor's note, do we need to refund them for the past 5 years? Do we have to refund their pet deposit?
Um, Interesting question. Well, if that animal, it depends on the situation. Again, it's very hard for me to answer specific, to talk about specific situation. But let's say hypothetically, a person lives there for 5 years, has a cat or has a dog, okay? Um, that dog was a pet, for example. But then it's possible that that person becomes a person with disability, okay, from certain point. Let's say God it's some car accident, has traumatic brain injury, has, emotional or some other psychiatric, psychological disabilities, and need to keep now that what was pet now is companion animal or service animal or assistance animals, okay? From that point on, that animal, if it's supported by documentation, would have to be treated as a companion animal or assistant animals, okay? And from that point on, a landlord cannot impose any fees or pet deposit, or, should basically stop charging those fees or pet deposit. Whether the refund, again, I can't give a legal advice, but just thinking here loud, you know, uh, that pet deposit was collected from a tenant during the time that the landlord had understanding that that particular animal was a pet. Okay, so if that animal was a pet for 5 years, um, there's nothing that would prevent landlord to charge pet deposit and keep that pet deposit. But from certain point on, then, a landlord cannot charge any fees. Whether a landlord at the end should refund that deposit, it all depends whether there was any damage, whether, how that animal is viewed.
Okay, last question. Does fair housing rules apply to visitors with service animals if the tenant on the lease has agreed that no animals would be in the unit?
Yes, if you have a tenant who is not personal disabilities and does not have any need for assistance animal or service animal, but has visitors who are people with disabilities, a landlord would have obligation, and that person, visitor, has a service dog or assistant animal, that landlord has to allow that person access to their premises. Again, it would be same as saying, okay, your tenant, you have your mother who visits you occasionally, and your mother is in a wheelchair. Have your mother leave her wheelchair at home and then walk to your unit. Okay, you can't do that. That person, visitor's dog or cat or animal, is the same thing as wheelchair to a person with disability. And you can't just prohibit or deny access to a tenant who has a visitor and visitor has a dog, because you wouldn't deny visitors to other tenants, visitors to other tenants. Other tenants are allowed to have visitors regardless. There are no limitations. So why would a landlord deny this particular visitor? Just because that visitor has a service dog, which can be viewed as a wheelchair, as a therapy for this visitor. So that's always help. I always compare it with a person with a wheelchair in my head.
Okay, there was a little bit of a follow-up question to the previous question.
Okay.
We have an illegal pet policy that charges a fee for an illegal pet. If we find a resident with an unauthorized animal, then a week later they get a note from a qualified professional, are they still liable for those fees as they hadn't made a request until after they were caught? And the letter wasn't issued until after the illegal animal was caught.
So again, it's I cannot really, I wish to be very helpful or helpful as much as I can and share whatever I know and be helpful to you, but it's very difficult for me to talk about specific situations. Yes, we've seen that. I've seen that, working on these cases, that people have animals in their units and they don't make any requests for reasonable accommodation. And after a landlord catches them or another tenant reports hearing barking or meowing or something like that, then individuals, those tenants provide doctors notes. So, it all depends. It's very hard for me to provide specific answer to this specific situation. But in general, if there is violation of landlord's policy, then the landlord has right to do whatever, his policy dictates, but if the tenant verifies disability and disability related need from that point on, that animal or that request has to be treated slightly different or much different. I don't know whether this is helpful or more confusing, but it, I really can't talk about specific situation because that particular tenant can tomorrow file a complaint.
All right, well, that is the last of the questions.
Okay, well, thank you all. If there are follow-up questions, you can certainly maybe send to Cheryl or Kylie and they can forward those to me and I'll be happy to provide as much answer as I can.
Yes, thank you so much for taking time out of your schedule to present to the group. Next week, Elena is also with us. She's going to be talking about modifications and accommodations. So thank you guys all for attending today's session, and there will be another survey sent out. So any feedback is great as we continue to plan these trainings. So thank you guys all for attending, and thank you again, Milena, for presenting.
Thank you. I'll talk to you next week.
Sounds good. Have a good afternoon, everybody.
Take care.